of our chapter on diversity, multiculturalism, and cultural intelligence. This recording will be slightly longer because we will be looking at the various types of laws that are covered by the Equal Employment Opportunity Commission, the EEOC. So the first one that we will be looking at is the Age Discrimination in Employment Act, the EDEA, which was coming into law in 1967. Like the other laws, this one is enforced by the EEOC, and as the name entails, it does prohibit age discrimination, and in this instance, it is for individuals who are 40 years old or older. So that's 4040. It doesn't mean that you have to favor somebody who's older than the person who is younger. What it means is that you cannot make unfavorable employment decisions such as hiring, firing, pay compensations, job assignments, promotions, layoffs, trainings, etc., with the person's age in mind. So you cannot exclude a person, for instance, from a training opportunity because they are 40 years old or older, right? So if you have somebody that you feel that they are too old for training and it's not worth investing in them, then they would be covered by this act. So we know that that is not legal. This act also does prohibit harassment, or it forbids harassment based on somebody's age. So one comment, one joke would not be covered. But if there are patterns of harassments, or if the harassment is severe, then that would be protected under the ADEA as well. The Disability Act is called the Americans with Disability Act, ADA, and it has been amended, so it's ADA-AA today, but that is beyond the scope of this course. This act covers individuals with mental and or physical disabilities, and it's also, of course, enforced by the EEOC. And here we are discriminating somebody if we are treating them differently because of their disability. And this applies both to job candidates applying for a job within the organization, as well as those who are already employed by the organization. And so both of those. So that means that in the hiring process, you also have to make reasonable accommodations if a job candidate needs it. So this ADA law requires an employer to provide this type of reasonable accommodation, which means that they might have to change or modify the work environment or the way that business is done, operations, so that it enables the person with a disability to take part in equal employment opportunities. It doesn't mean that the organization has to do anything that they are asked. It just means that they have to do things to accommodate the person that is reasonable. So if it was something that would put the organization out of business, or it would pose undue hardship on the business, they are not required to do it. So it's not a requirement that the candidate or the employee can ask for anything they want. It's rather reasonable accommodation so that the person can access the same opportunities as other people can. And to just continue with disability for a moment, it doesn't mean that we have to hire somebody who's not qualified for the job. In fact, all of these laws say that the person that is being hired still has to be qualified for the job, right? It just means that we're providing access to employment opportunities and employment decisions for these individuals to the extent that they are also qualified for the job. And here we are also defining what disability is. So I'm just going to go ahead and grab my pen again. So the law states that the person must be qualified for the job, as we said, and have a disability defined by the law, which can include the following: physical or mental condition that limits a major life activity. They have a history, right? So they either have the disability, they have a history of having the disability, right? So, for instance, a cancer that is currently in remission, or they have a physical or mental impairment that is not transitory, meaning it's lasting for a long period of time. And what is not up on this slide, and I apologize, I think I have a little bit of allergies, is also if the person is perceived to have a disability, but in fact they do not have a disability, they would also be covered by the ADA. So we are not to discriminate against people with disabilities. Then we have the Equal Pay Act of 1967, which says that people must be paid the same for the same type of work. So same compensation for same type of work. And this explicitly addresses sex pay differences or gender pay differences. And so this act looks at job content rather than job title. So they're looking at job content in terms of verifying that jobs are actually the same tasks and duties are being done by two people of different genders, and there's different compensation. Then this would be illegal under the Equal Pay Act of 1967. It does cover many different types of compensation, including bonuses, stock options, profit sharing, etc. And if it's found that there is inequality, then the organization cannot fix that by just reducing compensation for the person who has the higher compensation level, but rather they need to increase the compensation for the person with the lower levels. An employee can also file an equal pay charge directly with the court rather than going through the EEOC. So finding a lawyer and taking it straight for a lawsuit is possible for under the EEOC. Then we have Gina, who is the newer kid on the block. So this one deals with genetic information, and this is the Genetic Information Non-Discrimination Act of 2008, GINA. And the EEOC's definition of genetic information includes family medical information or information about the manifestation of a disease or disorder in an individual's family that would be uncovered during genetic information or from genetic information. So this law tells us the employer is not allowed to seek out this information, and they cannot use this information. So they cannot seek out genetic information by either requesting, requiring, or purchasing this information. Having this information might make it cheaper for organizations by not hiring certain individuals, etc., because of their medical history. As here in the United States, organizations are required to provide medical insurance, and many organizations go way beyond that. And so that it would be cheaper maybe to know these things, and that's why GINA is in effect. This law also details how we can keep genetic information in organizations, and specifically says that this genetic information must be kept separate from an employee's regular personal file. So in the instance that we have genetic information, it cannot be filed in the regular personnel file. And so this slide talks about those instances where we might actually have this information or come across this genetic information. Again, not for us to use unless our occupation or industry specifies that we are able to use genetic information. So there are exceptions, and then of course you always want to check with a lawyer or with an attorney to see whether your company or that job specifically would qualify. So there are some situations in which receiving genetic information would not be illegal, and so you can pause the video if you want to read through all of these. So I'll just hit on a couple of them. So for instance, if you're overhearing this information, right, so employees are talking and you happen to hear this, well, that is not illegal. If the employee is requesting, for instance, a leave, an unpaid leave through the Family Medical Leave Act, FMLA, then some of this information must, or not must, but may be made available to the employer. Um, for instance, there are some professions that require DNA testing, such as law enforcement. So here, genetic information can be used in that analysis. So again, some occupations or some industries, but check with the lawyer unless you already, like law enforcement, know what the rules are around GINA. Under the Title VII of the Civil Rights Act of 1964, it is illegal to treat people unfavorably because of their national origin, because they are from a particular country or part of the world, because of their accent, like I have an accent, or because they appear to be, they look like they are of a particular descent. And so the flag on this slide is Finland, the Finnish flag, and that's where I am born. I'm born in Finland. So, like all these other acts and laws, this refers to all aspects of employment, including hiring, firing, pay, job assignments, promotions, etc. An employer can, however, require employees to speak English, but only if that is necessary to perform the job effectively. So we cannot request English unless we have a business reason for it, because again, that might discriminate against people from other nations, with other national origins. Here in California, which is where I am based, we have a California law that states that an English only policy can only be used if there's an overriding legitimate business purpose, such as being, quote unquote, necessary to the safe and efficient operation of the business. As a result, a policy such as this could be considered discriminatory and should be used only when absolutely necessary. Pregnancy, which is an amendment of the Civil Rights Act of 1964 that covers sex discrimination. We have the Pregnancy Discrimination Act that came into being in 1978, and that covers the unfavorable treatment of a woman, right? Because still today, only women can become pregnant. So unfavorable treatment of women because of pregnancy, childbirth, or any medical condition that is related to pregnancy or childbirth, they are protected. So a woman who is unable to perform her job because she is pregnant, she must be treated the same as other temporarily disabled employees. So they can request modified tasks, or not request, but the employer is required to give them modified tasks or alternate assignments. But we cannot treat them unlike other employees. In the sense, we cannot discriminate against them because of the pregnancy. We also have the Family Medical Leave Act, which gives 12 weeks of unpaid leave for childbirth, and that is not just for women, that is for anybody who needs it. And that is unpaid leave for childbirth, adoption, caregiving of somebody who's sick in the family, or medical leave for the employee themselves. Excuse me, my allergies. The FMLA is enforced by Department of Labor, the US Department of Labor, and it covers companies with 50 or more employees, and the employee must have worked at least 1,250 hours over the past 12 months with the organization. Then we have race and color, which is also covered under the Title VII of the Civil Rights Act. Race and color discrimination refers to treating someone unfavorably because they are of a certain race or because of specific characteristics of that race, such as, or possibly including, hair texture, skin color, or facial features. Discrimination can occur when the person discriminating is of the same race. So just because I am of one race and I tease or harass, rather harass or discriminate against others of my own race, it doesn't make it okay. And I will also mention here that all, right, all colors and all races are protected um, under the Title 7 of the Civil Rights Act. The EEOC also protects people who are married or associated with someone of a race or color, that and they are being treated differently or discriminated against because of that. And like all of the other laws that we've talked about, it covers all of the employment decisions. Then we have religion. Again, this one falls under the Title 7, and religion is covered in the sense that we cannot treat a person unfavorably because of their religious beliefs. That is illegal. Like the Disability Act, the ADA, the Title 7 requires reasonable accommodation for a person's religious beliefs or practices. Again, unless doing so would burden the organization's operations. So if it puts undue hardship on the organization is not required to do it. So ideally, the employee or the applicant during the job process, the selection process, would notify the employer that they need some sort of accommodation, and then they would have a conversation around that. So if there's no hardship that would be posed, then the employer should honor the request. And if the request might cause a disruption or a safety issue, then the request might not be honored. So again, as an employee or as a candidate, we cannot require certain things, but if it is within the bandwidth of the organizations, they should honor these reasonable accommodation requests. Then we have sex and sexual harassment, again under Title 7. And so that involves treating someone unfavorable because of their sex. The same as with all of the prior EEO laws, it requires for all of the employment decisions that we're making that we do not take sex into account. So we cannot discriminate based on sex or gender. It also includes sexual harassment, which means that we have unwelcome sexual advances towards somebody. And the key here is unwelcome. As long as these sexual advances or jokes, requests for dates, touching, whatever that is, as long as they are unwelcome, it is illegal. It is illegal. And so they might be welcome yesterday, but unwelcome today. So today they would be illegal, but yesterday they would not have been illegal. So when we talk about sexual harassment, we have two types. The first one is called quid pro quo, and the second one is called a hostile work environment. So quid pro quo means this for that, as you might already know, and that means that a type of this is a type of sexual harassment where one person, typically a person of power within the organization, is requesting or asking for something from the other person, the victim, typically the person that has a lower level of power within the organization. So maybe the employee. So you have maybe an employee and a supervisor. So the supervisor is trying to trade something for sexual favors or a date. So, right, if you go on a date with me, I will give you a promotion. And that would be quid pro quo sexual harassment. The hostile work environment looks a little bit different, and we have sexual harassment happening here where there are sort of a pattern of joking or teasing, or there is in the building there are posters of sexual or similar nature. So the environment itself is kind of hostile towards one of the genders. And so this is more of a pattern or more of a consistency and more diffuse than the more straightforward quid pro quo. So you have quid pro quo and hostile work environments. And the last bullet point here tells us the victim can be of any sex, of course, and the harasser can be of any sex, and the harasser and the victim can be of the same sex or of different sexes. Then we have USERA, the Uniformed Services Employment and Redeployment Rights Act, which protects people who serve or have served in our armed forces, in our reserves, in our National Guard, or in other uniformed services in the United States. Not the service doesn't have to be in the United States, but they have served the United States. This act ensures that individuals are not disadvantaged, right? So we can't discriminate against somebody in an organization because of their past military service, or their current service, or their future service. It also requires that the organization brings the person back and re-employs them in the same or similar job as they had before their service. And to all of you listening who have served, are serving, will serve, or have family members that are serving, have served, or will serve, I thank you for your service. Then we have retaliation. So in all of these laws, the EEOC, Equal Employment Opportunity Commission laws, also makes it illegal to retaliate. So we cannot fire, demote, harass, or in any other way retaliate people because they have filed a charge of discrimination, they have complained about discrimination, or participated in employment discrimination proceedings. So these individuals are covered from illegal treatment because of filing a charge, complaining about discrimination, or participating in employment discrimination proceedings. Rather. So this is from the textbook, and this details the process that EEOC works through and the requirements that the EEOC has. So the requirements are listed here on the left side, and it says, like we've said in other recordings, that the organization has to post the notices, the EEOC notices, so people can see them, employees can see them. They have to file yearly the EEO1 form, which details the demographic breakdown of the organization, so we can monitor for discriminatory practices. And it is good to keep all copies of documents on file in case there is an EEOC investigation that you have to bring forth evidence or answer questions. Then we have the process for investigation. So firstly, the complaint would be filed with the EEOC. The EEOC would notify the organization that there is a charge against them. And then the EEOC would act as sort of a mediator between the employee and the employer to ideally find a solution before it goes to court, right? So we're trying to solve the issue before going to court. And if that is unsuccessful, then the EEOC will initiate an investigation. The EEOC might make a determination, and then the employer has the option to remedy the situation, right? So if the finding is that something has to be fixed with the organization, right? We're not hiring enough men, then the organization might have the opportunity to come up with a solution that would cause them to hire more men. And then that would be the end of it. And if the organization does not comply with that, or is resisting for some reason, then either the EEOC can file a lawsuit on behalf of the complainant, or the EEOC can give the complainant a letter that essentially says that they are free to file a lawsuit on their own against the organization. So for exercises, we have two. For the first one, go ahead and visit the EEOC website at eeoc.gov and explain the methods that you could use if you needed to file a complaint with the EEOC. And secondly, if an employer is found to have discriminated, what are some of the remedies, quote unquote, that are listed on the EEOC website? In summary, the EEOC, the Equal Employment Opportunity Commission, is a federal agency charged with the development and enforcement of laws relating to multiculturalism and diversity in the workplace. The EEOC covers discrimination based on several areas, and companies cannot discriminate based on age against people who are 40 years or older. They can also not discriminate against people with disabilities, mental or physical, and they must provide reasonable accommodations, such as the addition of a wheelchair ramp to accommodate those with physical disabilities. Equal pay refers to the fact that people should be legally paid the same amount for the same job that they are performing, even if the job title is different. Then we have GINA, which is the newest EEOC law that prohibits discrimination based on genetic information. Unfavorable treatment of people because they are from a particular country or part of the world or have an accent is covered by the EEOC. Also, an organization cannot require people to speak English unless it is a requirement for the job or needed for the safe and efficient operation of the organization. Women cannot be discriminated against because they are pregnant. The inability to perform certain tasks due to pregnancy should be treated as a temporary disability. Accommodation can be in the form of modified tasks or alternative assignments. The EEOC protects people from discrimination based on their race or color. Religion is also an aspect of the EEOC family of laws, and the protection of religion doesn't allow for discrimination. Accommodations can include modifications of work schedules or dress to be made for religious reasons. Discrimination on the basis of sex is illegal and covered by the EEOC. Sexual harassment is covered as well, and it states that all people, regardless of sex, should work in a harassment-free environment. Retaliation is illegal. An organization cannot retaliate against anyone who has filed a complaint with the EEOC or filed a discrimination lawsuit or participates in an investigation. The U.S. Department of Labor oversees some aspects such as the Family and Medical Leave Act, FMLA. This act requires organizations to give 12 weeks of unpaid leave in the event of an adoption, birth, or to provide care to sick family members or for themselves if they have a medical condition. So with that, we're going to close this a little bit longer video out. Hope you're all safe and see you soon. Take care.